filed by defense was prior to today. That was the motion that we filed to strike their motion for an order to show cause. So we had a motion for order to show cause that was filed prior to. But now, because the deposition was supposed to take place today, I think at 11.
Wash. Grant that, then all the other stuff goes away.
Correct.
For now.
Correct. For now.
For now.
For now.
But then it has the ability to continue to come back. So if we go to the other portion of it, maybe we can resolve without.
I don't think you could. And I'll tell you why. The reason why is because yes, it could come back, but you would consider my alternative motion, the motion for protective order at this point, because 3 witnesses have testified now.
That's what I'm saying. I would rather deal with that than the initial.
Yeah, well,
to the heart of the matter.
Yes,
Judge. Giselle,
Giselle's my assistant.
Recording in progress.
And James Beard is the California officer. And Judge, regardless of what your decision is on how you want to handle it, I know Mr. Beard has a scheduling issue, so I just want to get him out of the way. And then the court can decide however it wishes. I let him know we're trying to get him as quick as possible.
And for efficiency purposes, Judge, if Mr. Beard is going to testify that what's in his affidavit, I'll stipulate to that affidavit. I'm very happy with that.
Actually, there's an affidavit filed that is now contradicting everything that he said, and I just want to get some testimony from Mr. Beard. Specifically contradicting what he said from the security that was there.
By the way, if you guys announce yourselves for the record.
Oh, Mauricio Padilla on behalf of Diedrich Williams. Brad Cohen on behalf of Aubrey Drake.
Brad Cohen on behalf of Mr. Graham.
I see Mr. Baird's on there.
That's a lovely picture.
Yeah, it's me.
That's a great picture of you.
I was a little bit thinner.
Yeah, you look great.
A little bit thinner.
Relaxed.
These trials made me a little fatter.
It's okay. Maybe a little balder.
So,
Yes.
you want to just take some testimony?
Yeah, real quick to get him out of the way, Judge.
I mean, what's in his affidavit and the affidavit we filed from the security guard is pretty much the same thing. I mean, it's said in a different way.
It actually is not. It completely misstates what occurred, and I would just like to get him on the record now that I have him present. Judge.
Yeah, we also need your client.
Well, my client waived. My client waived because my client came out here and he wasn't properly dressed, and I told him that if he wanted to, he could waive it. And he's
So
I should have done that on the record.
correct.
Okay, sorry.
Yeah.
Yeah, sorry.
Did you go back already?
Yeah.
Sorry, Judge.
Isn't he being kept in this particular jail? I mean, it's a first-degree murder charge.
Has he already been sent away, or how far away is he?
He needs to put it on the record, Judge, for appellate purposes that he's waiving.
How far away is he? Will he go all the way back? All the way back. How long will it take to get him? You guys can relax from
Okay, great.
I'm always relaxed, Chris.
You were very relaxed.
Very relaxed.
before I'm gonna go forward on a hearing on, that involves him, is just saying, I don't wanna be here is not enough unless I
Yeah.
hear from his own lips that he doesn't wanna be here.
Yeah, understood. And now that he's
Why-
already
why
here,
not?
and now he's already here, he's already gonna,
All right.
he's gonna sit through.
Very well.
And just, we have Mr. Baird on the screen. I just wanted to get some testimony from him because I know he's on a time crunch.
I don't, I can be
All right,
honest with you.
so you can unmute. Bear, unmute.
You gotta hit unmute.
Unmute. Not
Unmute,
unmute.
unmute, right, unmute.
What did you say?
I said unmute, I think.
Sounded like unmute.
The little microphone.
Don't get it. You already unmuted once. You have to unmute, sir.
Oscar doesn't hear you.
Judge, if you send him a request to unmute,
No,
you
it's
can
All
accept
right.
it.
I'm on the call on the phone. Let's get it.
I know he knows how to do it because he just unmuted.
Okay.
You did it earlier.
There you go. Oh, no.
No,
That's
that's
not
not
it.
him. No.
That just makes it.
You have to unmute, sir. You have to unmute. You gotta hit the unmute button so we can hear you.
Does that touch
You gotta hit the unmute. You're muted now. They're gonna send you a little.
Now he's unmuted.
Okay, now you're muted. Okay.
Okay, there you go.
Sir, can you hear me?
I can hear you.
Raise your right hand if you sworn. And you can see the right hand.
You gotta show him your right hand.
Raise your right hand if you sworn.
You have to raise your right hand, sir.
You swear the testimony you're about to give in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Put your hand down, state your full name, spell your last name for our record.
Sir, did you hear the court? You have to give your full name for the record.
James Nelson Bader, B-A-I-R-D.
Mr. Baird, are you a licensed California processor?
Yes, registered California processor.
Okay, and did you have the opportunity to attempt service on Aubrey Drake Graham?
Yes.
On what day did you do that?
What date?
Yes, sir.
Well, I want to make sure I'm reading the right one. I think it's February 14th.
Okay, February 14th. While you were attempting service, was video taken to memorialize the attempted service?
Good question, Dan.
When on February 14th, when you attempted service, was there video taken to memorialize the service?
There was a video taken from what?
On February 14th, was video taken of your attempted service?
Yes.
Okay. Were there three different video clips taken of the attempted service?
I have it in front of me, the video.
I understand that, sir. Were there three different video clips taken?
What's your question?
Did you take three different video clips?
What, do you see the one I have here?
No, I'm going to show you one now, okay? Giselle, play the first one. Share the screen and play the first one. I'm going to show you a video, sir.
Judge, I'm going to stipulate to the videos. That's it. I just want to, let's just get the testimony that we need to out of him that contradicts allegedly my affidavit. and we can kind of move this along, because I'll stipulate to the video, I'll stipulate to his affidavit, the information in his affidavit I'll stipulate to. I just want to find out what he's saying that's different than what my guy's saying.
Judge, I have video evidence. It contradicts the affidavit that he filed. I have my witness there, and I would like for him the opportunity. So, share the video, please.
It's not allowing me to share the video. It says the host has removed participant share screen.
Hold on a minute, we're trying to fix it. That's great. This is occupied. I did this thing is testimony, and then it's very soon. I don't know what the big just
I think it's sharing now.
Giselle, try it again, please.
Judge, since they wouldn't take my stipulation to let the video in, if we're going to do it through this witness, then I can object to it if he's doing it through this witness, because California is a two-party recording state. To my knowledge, the other party didn't accept the recording on private property. So I think that if he would have accepted my stipulation, I probably would have been okay with it. But if we're going to go through this guy to get it in, now I'm going to raise an objection. And I'm going to say California is a two-party state. We all know what a two-party state is, meaning both parties need to agree to being videotaped or filmed on private property. This was not in a public atmosphere. This was not on a public road. Even pursuant to his own affidavit, he says he was on private property because the security guard said, hey, get off the private property or we're going to call the police. So there's nothing in his affidavit. There's no testimony, nor is there on these videos that show they're in a public realm. So there's nothing that says, hey, I agree to you taping me, I'm okay with it, or that I accept you videotaping and audio taping me. So obviously I have to object. And I think in California, when it's a two-party state, I almost think that it's a felony to do it, but a misdemeanor, excuse me. I think it's a misdemeanor to do it, but I don't want to quote California law, we're in Florida. But long story short is I can't object to it coming in at this point because it's a two-party state. There's no acceptance by the other party. There's no video showing that there's acceptance by the other party, and it's on private property.
Okay, Judge, that mischaracterizes California law. It's incorrect what he's saying. The issue of a private conversation, the area where this was filmed was outside of the home, and that is not private as stated in California law. I have a California attorney, and I've asked her, if this is going to get to the point that we're arguing California law, I would like for her to chime in because I believe that completely mischaracterizes what the California law is. Let me look for the email where she addresses it so I can read it to the court. Okay, the two-party recording state doesn't apply. It's Penal Code 632, and it only applies when it's a private conversation and the parties have a reasonable expectation of privacy in the conversation. These are armed guards that are standing outside of a property that are being addressed by a process server. This is not someone in a living room or a kitchen having a private conversation. There's no expectation of privacy when you're doing your job and a process server is walking up to you. This is not the type of thing addressed by California Penal Code 632. So that's not consistent with California law. I have hired a California attorney, which can chime in if the court wants. I'm simply trying to show the attempted service, which is par for the course, Judge. This happens all the time. So I don't believe that his objection has any validity. Specifically, my California attorney doesn't believe that has any validity. The witness is here on the stand. That's it.
Judge, he didn't address that it's on private property. It was not in a public realm. It was on private property between two individuals, obviously Mr. Baird and the security officer. There's 100 feet of driveway before the main gate of the home. That 100 feet is still his property. They walked up, pursuant to his own affidavit, they walked up the driveway. They met the security guard at the gate at the top of the driveway. That is private property. There's no acceptance, there's no doubt that there was a discussion between two individuals on private property where one individual did not allow the recording. He did not accept the recording. I don't see where else. It doesn't need to be in the living room. It just needs to be an expectation of privacy. You're on private property having a discussion with an individual about, I don't know if he's serving him or whatever it is, whatever's in the affidavit, but certainly there is an expectation of privacy. There's no way around that. I don't understand why it has to be in a living room or a bedroom. It doesn't. There's no case law that they could ever produce that, number one. Number two is, we're in Florida. It's great that a California lawyer wants to chime in, but it's not hard in Florida. The law is very clear, and the law is a reasonable expectation of privacy. You're on private property. Right off the bat, that should suggest that there is a reasonable expectation of privacy. If I'm in the confines of my home, and I don't mean in my home, but in the area of my home on private property, I'm not expecting to be recorded. These security guards are not expecting to be recorded. They're not outside by the street. They're not on the corner of the driveway. They are at the front gate of the home that's 100 feet in from the road. Now, if it was 5 feet in from the road, okay, you might expect Google Earth to come by and record you. You might expect some guy to record you from a car. That's not what happened here. He walked up the driveway, pursuant to his own affidavit. He walked up the driveway, confronted the security guards on the driveway on private property, and then said whatever he said, and the security guards said whatever they said. Now, that being said, I don't have an objection to his affidavit that says this is what they said to me, this is what I said back, his actual affidavit. The fact that Mr. Padilla quoted the video in his motion, I didn't file a motion on that because I didn't expect the video was coming in because there was so much testimony as to what happened on the video. The only reason to show this video now is some salaciousness, something that's sexy, where a security guard is telling an individual, "I'm not accepting service." Put all that aside. The fact of the matter is, it's still a two-party state. There's no testimony. There's nothing in the affidavit that says this individual said, "I'm okay with you recording me."
Judge, if that was the case,
Continue to ask your questions.
okay. But I just want to make this argument real quick. Judge, if that's the case, TMZ and paparazzis would never be able to take a picture in California. So that's incorrect. And I understand that this is Florida, but he's quoting California law. He talked about case law, but he didn't bring any, nor did he bring a California attorney to educate the court on California law. Sir, I'm going to show you a video for that's going to be shared. Giselle, share the video.
Are we sharing the video, Judge, or is he asking a question? Because the fact that he brought up TMZ is interesting because that's all on public property. Even TMZ knows that they can't go up someone's driveway and start recording somebody on private property without their acceptance. And I'll give you one further. When they come in with a big television camera, you understand that you're on TV because it's a big television camera. This guy recorded unbeknownst to anybody, and it just shouldn't be coming in. It's not just the fact that it's a two-party state. It's the fact that you didn't get permission from the other party. And I can give you all the case law you want, Judge. It's a reasonable expectation of privacy is on someone.
Objection sustained. I don't need to see that.
You don't need to see the video?
I'm willing to listen to the testimony of the witnesses who were there.
Okay. Sir, when you approached the home of Aubrey Drake Graham, did you identify yourself as a process server?
Affidavit.
Sir, when you went to the home of Aubrey Drake Graham, did you identify yourself as a process server? Mr. Baird.
Are you speaking to me?
Yeah, sorry. Mr. Baird, I'm speaking to you. When you went to the home of Aubrey Drake Graham on February 14th, Did you identify yourself to security as a process server?
Yes.
Okay. What occurred after that?
I have a card. I have a process server card.
Okay. Did you identify yourself and show that card to the security?
I identified myself as process server to the security.
Did you tell them what pleadings you were serving? Did you tell them what you were going to serve?
Yes.
Okay. Did they accept those papers? Did they accept those papers?
No, immediately I was told that there would be no acceptance, no admission, and he would not call the witness, Aubrey Brennan.
Did you
No
ask?
cooperation at all.
Did you ask him to call him?
Yes.
How many security guards told you that they would not accept service?
There were two there, but I was mainly speaking to one particular one. The other one stayed in the background on the property.
Did you at any moment become frustrated or upset?
Question again.
Did you at any moment become frustrated or upset?
No, I stay passive. I mean, frustrated mentally, but I just repeated and emphasized that they are required to, at least, if I cannot gain entrance for some reason, but I'm legally completing a service by leaving it with security. That's California law. No access, and he may leave it with security.
Okay, and did you in fact do that?
Yes.
After
He did
you,
not take it in hand. He started ordering me off the property. After several attempts, say it was frustration, but it was not anything but passive, polite request to leave it, and he insisted that I leave right away, and he became the overall negative, or he's threatening to call the police. So in the end, after several attempts, and I didn't approach him hardly enough to, he would just chase me away. So I had to leave it at his feet.
did you,
Some distance away. I couldn't go up to it and hand it to him.
after you left it on the floor, what did he do with it?
Ordered me to leave, and by the time I got down to the bottom of the driveway, he had started kicking it down the long driveway, multiple foot kicks. So it eventually wound up in the street. He had to leave. There was nothing that could be done.
Okay, and sir, in your work as process server in California, have you before or videotaped a service to have proof of the service?
I have a videotape of this service.
My question is, in California, do you memorialize process serving through video sometimes?
I don't know what you're asking about. California memorialized what? I have a registration card.
I understand, sir.
I'm currently registered.
Okay, I have no further questions.
Here's the card.
Yeah, I see it, so it's great. Mr. Baird, can you hear me?
Question.
Can you hear me, Mr. Baird?
Turn the volume up. It's a little low.
Yes, let's turn the volume up.
Okay, go ahead. I'll hear you better now.
Thank you. My name is Brad Cohen. I represent Mr. Graham. Okay? I'm going to ask you some questions. Sir, do you understand me?
I'm just trying to see if I got your name here on your proof
me. All right? Mr. Baird, can I ask you, and this isn't in an insulting way or anything, do you have issues with your hearing?
You have to repeat the question. Issues with my appearance?
No, sir. Issues with your hearing. Your hearing.
Hearing issues?
Yes, do you have any hearing issues?
You said hearing, right?
Yes, sir. Not herring. Hearing. No. There's no help that needs to be given. This is a
I don't know what your question is. Do I have issues with
hearing.
Yeah, he obviously does.
Okay, that's what I need to know.
When you have to slow down and be very clear when you say that word.
Yes. Sometimes I speak quickly. Do you have problems with your hearing?
No.
Okay, fair enough. Who was that who just walked in?
Yeah, the audio is actually good. It's kind of muffled in the background. That's one problem there. You don't understand.
How old are you, sir?
State that again, please.
What's your age?
Your question.
How old are you?
81.
Okay. Let me ask you something, sir. How long have you been a process server?
Oh, decades. I don't know when it started.
Okay. When you say you left it at the feet of a security guard, is that accurate?
I had no other choice. They have to take it by law, even though I couldn't get his name, even though I couldn't have him officially call. I don't know. They were doing things for a while. It was 5 or 10 minutes. But I don't believe they called the witness. And I never got the name of the security. The only thing left I could do is leave it on protest, under protest. That was all the best I could do.
Leaving it under protest, you dropped it on the driveway, correct?
I could not put it into his hand. He would start to chase me away, threaten to call, wave his hands like that and tell him, no, you have to leave, I'll call the police.
You dropped it on the driveway, correct?
Yeah, in his presence.
Okay.
And he,
Was it?
I should have been there dropping it in front of him, right, not up real close, but there was no question. He was watching me drop it basically in front of him.
Was it in a manila envelope when you dropped it on the driveway?
What's the question when I dropped it on the driveway? What?
Was it in an envelope?
It was partially pulled out. You can see the document in the envelope.
You stated that he never picked up the document, that he started kicking it down the driveway. Is that correct?
I heard the last part. He did very clearly, about 10 times, 15 times, kick it on further and further, step by step, down the driveway. Very exaggerated, but that was by kicking it.
Sir, is this a gated community?
Question?
Is this a gated community?
No, it's a long driveway going up to one large, very large gate that is solid. You can't see through it. You can see the house further up, but it's not very visible. And it's just that one residence at the end of the driveway.
You signed an affidavit on February 17th. Yes?
Yeah, I have it here.
Good. In that affidavit, it is for an attorney, correct? You provided it to an attorney?
The affidavit states what?
The affidavit, who prepared it?
You're cutting out.
Okay. Who prepared the affidavit? You typed this affidavit, sir?
I don't understand your question. I authorized it and prepared, went through the case very thoroughly and signed it. Now, what would the question be?
Who typed the affidavit for you?
Well, you're questioning my signature. I don't like answering your question. I signed my affidavit. Period. That's it.
Gotcha. Who prepared the affidavit? If we can ever get there, who prepared it?
Well, you're in a remote session now. You know that I said I signed my affidavit. Now,
Sir,
does everything are you
the question.
or do you have other people help you? Come on.
Answer the question, sir.
That was the judge. He said, answer the question. Who prepared the affidavit?
Mauricio knows that I prepared it.
Mauricio knows you prepared it.
And
Okay. You typed it up with your own hand, right?
I did sign it, yes.
Okay. Sir, you testified earlier that you asked them to make a phone call. Is that correct?
As the security guard, correct.
To make a phone call.
I asked the guard to make a call. Now that's what you're repeating, and I confirm.
Okay. Did you put that into your affidavit, sir?
I believe every detail is in there. I may be thorough and review it. I have it in it. My declaration, as it's called, not an affidavit, of attempted service. Now, you must have read what the question.
Sir, you testified that you asked them to make a call. I'm asking you. Hold on, sir.
It's a four-global connection.
Sir,
On it.
hold on. Let me finish my question. You earlier said, I asked them to make a phone call to Mr. Graham. That is your testimony, correct? Under oath, correct? That is a yes or no, sir? Is that your testimony?
I'm reading the affidavit. And your question again is what?
The question is, did you testify earlier that you told them to call Mr. Graham? That's the question. Yes? You can look at that affidavit.
I'm trying to see if it says it here on the affidavit.
It doesn't. It doesn't. I'm going to let you in on a secret. It doesn't say it in your affidavit.
The detail. They wouldn't give me the name.
Right.
They wouldn't call.
Let me cut to the chase, sir. Can I cut to the chase, the big reveal? It does not say it in your affidavit. And earlier you said you read the affidavit. It's very thorough. I know what's in that affidavit because I make them thorough. But you didn't put that in the affidavit, sir, did you?
I didn't put on the affidavit that I told them to call.
No, you didn't put it in the affidavit.
That was his answer.
The one that you typed.
As soon certainly did tell them. Now, I can find the word.
Maybe that's it.
So, exact wording, you want to.
Yeah, the exact wording, sir. But you did state that you drop served it, correct? That was not a posting, it was a drop serve, correct?
Well, if you can't put it in the hand of the person that you're dropping it in front of them,
Yes.
that is legal.
Great. But that's called a drop serve, correct?
Well, you saying it, and it's slang if you want, but it was left, and the requirement is that you have to leave it.
I understand,
If you
sir.
take it in hand, then you have to drop it.
Sir, your affidavit on page 2, it's not slang I'm using. This affidavit that you read so thoroughly, that you typed up with your own hand, you wrote in paragraph 4, thereafter, I posted the subpoena and notice of deposition by drop serve. Those are your words, sir, not mine. Correct?
I'd like to answer your question, but you know, this audio is not where I can really follow what you're saying. You're questioning whether
Sir,
get them to call, they would not call, and I had to quote unquote drop serve because they would not take it in hand, told me to leave, and would not give their name. That's it.
right. And you got it on audio that you asked them to call, though, right?
Question again.
Yes or no?
Objection, mischaracterized prior
Your
testimony.
question was, did I have
Did you get it on audio? Did you get it on audio?
Objection, argument.
Yes or no?
Objection, argument.
to protect it? I put it partially in an envelope. It was visibly a document extended out of the envelope.
Yeah. Did you get that on video, sir?
Did I do what?
The partially exposed in the manila envelope that
Yeah,
was
it
closed.
was like halfway in.
It was halfway in.
Or even further out. It was out of the envelope, but I just provided something to enable like a courier handling, not lose pages. It was a consideration.
Gotcha.
It was very visible as a document.
Thank you, sir. I appreciate your testimony. You got that on video too, right?
Question again.
You got that on video that it was halfway out of the envelope, right?
Yeah, well,
Yeah.
it eventually got inserted the whole way, but he saw it was a document.
Who insert, sir? Now we're coming into a new realm. Who inserted it? You?
I think you asked if it was me that was serving him.
No. You put it in the envelope and dropped it on the ground, correct?
But I had shown him that it was a document, and then I put it in the envelope and dropped it.
That's what I want to know. And you left it in the envelope on the ground, correct?
To protect it, but he was very aware that it was a document.
Great. Thank you.
Sir, they're asking you questions about the audio. Do you have problems hearing this particular Zoom hearing?
Questioning, talking to me.
Do you have problems hearing this particular Zoom hearing?
Do I have problems hearing?
The Zoom, this Zoom, the audio on the Zoom, is it okay?
The ongoing hearing now.
Okay, got it.
Yeah, it's
Sir,
50 quality. I can't, it's in the background, it's distorted a little, and it's not clear, it's not good quality at all.
sir, in your career as a process server, what you did in this particular case, is that valid service in California?
That's an objection, Judge. Is asking for a legal conclusion.
Is that-
That this guy can't even, he can't even testify.
Judge, I'd like to make an argument to the court while I still have him on the stand. Mr. Cohen has attacked his ability to hear. He's attacked whether or not what occurred on that video, and he's asking the court to not allow it pursuant to 632 Penal Code. 632 Penal Code says that a communication is considered confidential if it is not intended to be overheard by others, if there's a reasonable expectation of confidentiality by any of the parties involved. Obviously, Judge, these are armed security at the gate of a mansion. This is not the type. So now the issue is, after what he's done to this witness, now the video is completely relevant because it backs up everything that he said. And he's done a fine job of trying to, attack his credibility and what occurred. So really now the video really is an issue. And California Penal Code 632 doesn't apply. That's where the two-party argument that he says is. So I'm asking now that I be allowed to show the video.
Two things. One is, I'm stipulating to his affidavit. It's everything in his affidavit. The fact that he can or can't hear, there was a guy who just popped in on the screen and goes, obviously he can't hear, and he popped back out, which may be his associate, which I still have, after he's finished with his redirect, I still have a question who that individual is who just walked out. But that being said, the only thing I'm questioning is his hearing. That's what I'm questioning. I don't care about anything else. I asked him if it was in the document that he asked them to that call Mr. Graham. He said no, it's not in the document. Then I asked him if he got it on video. He said no. It's not. It doesn't make the video relevant that he just said no. He didn't get it on video of him allegedly asking to call Mr. Graham. That doesn't make the video relevant anymore. It's this exact same thing he just testified to. We heard what he said. He dropped it on the ground. He testified everything that he just said. That he put it in the envelope, he dropped it on the ground, they kicked it down the street. There's nothing that he testified to that I'm questioning in the video. The only thing I was questioning, which it makes the video non-relevant, is the fact that he didn't get the question of call Mr. Graham on video. So it's actually the opposite. I'm not making the video relevant whatsoever. I'm making it even more irrelevant because he didn't even get the portion where he allegedly said, not only is it not in his affidavit, but he didn't even get it on video of him allegedly saying, call Mr. Graham, I'm a process server, call Mr. Graham. He just said he didn't get it on video. So how am I making the video more relevant by him testifying that he didn't get the most relevant part on the video, which, again, is not that relevant because the service is bad anyways. But putting that all aside, there's no way I opened the door here. I actually opposite opened the door, is I shut the door even further when he testified that he didn't get on video asking them to call Mr. Graham. He admitted that. So now I even have more of an objection that now it's a selected amount of video that does or doesn't exist. He took some, didn't take some. Now I don't even think it's, besides it being objectionable because it's a two-party state, now I think it's further objectionable because now he just picked and chose what he put on video and what he didn't put on video. If there wasn't a conversation about him asking them to call Mr. Graham, that's even more objectionable. But I'm putting that aside. The argument's the exact same argument he made at the very beginning. The only thing different now is saying that I opened the door, which I didn't open the door.
He completely opened the door, told him to question everything about this gentleman, whether he's an effective process server, whether his hearing is good, every single thing. The video speaks for itself. He's mentioned it ad nauseum. I believe at this point, he should be able to show it. We should be able to see it. And his argument about the two-party state and California is not relating to this. This is a process server serving an armed guard that's doing his job. There's no reasonable expectation of confidentiality pursuant to the California Penal Code that I just read to this court. So I'm asking the court to allow us to view the video.
That's denied.
Okay. All right. I have nothing further, Mr. Baird. Thank you. Thank you, Mr. Baird. Thank you, Mr. Baird. You can log off. Okay.
Told me to log out.
Yeah, you can log out. You can log out.
It's hard to hear this poor audio. My equipment is good, but when you give us off, it's poor, very poor. So you should log out, right?
Yes, sir. Thank you. Thank you, Mr. Baird.
All right.
Judge, motion to quash yesterday, wherein they basically, for starters, I was pretty shocked because the way that they start the motion is that they say that if not quashed, then protective order should be granted, as now the individuals, Investigator Curcio and cooperating witness, both testified that non-party had nothing to do with it. So I'm really shocked that a criminal defense attorney in a motion is basically telling you, believe a detective, believe a cooperating witness, and don't allow me to take testimony from somebody. At the end of the day, what occurred here is very simple, Judge, because you were part of it. We came here on February 13th. The court vacated an order, and when the court vacated the order, the language from the court was clear. Cooperate with each other. It was a professional courtesy. You even said, listen, he could pick a date that's convenient to him. I'll even consider sealing it. We could figure out the topics in advance. What did they do? Okay. The next day, I went to go serve his office. I'm not accepting service. The next day, I spent I cost to my client to go over there and properly serve them, domesticated with a California attorney, and the armed staff not only refused to accept service, but threatened to call the police. So after you, in all professional courtesies, extended that and vacated it, what did they do? They refused to accept service. Mr. Cohen filed a general notice of appearance, Judge. He didn't file a limited notice of appearance. And when he did that, he waived personal jurisdiction and he waived any defects in service. I have a case for the court, Watson v. Bianchi, 162 Southern 3rd 102, which basically which basically delineates that it's established Florida law that if you file a general notice of appearance, you're waiving personal jurisdiction. So that's what he did. He didn't file a limited notice of appearance. So then what does he do? Then he goes when Leah Volmick, the California attorney, reaches out and says, hey, are you going to accept service? Because she doesn't want to approach the client because he's represented. He emails her back and says, no, I already said I'm not going to accept service, and mentions attorney's fees in the email. So the next day, after you provided that professional courtesy, they're already threatening attorney's fees. Then what do? They filed multiple motions to quash, and one of the things that they did is they filed a motion to sanction me. Okay, they want you to sanction me, and when they did that, they asked this court for affirmative relief. And so by doing that, that's even more of a reason that Aubrey Drake Graham is now in this case. He doesn't have the luxury of asking a court for affirmative relief, and then I'm not going to accept service. It's basically what's happened here. Now, they get into...
Judge, if I can just, I don't want to interrupt, but it's my motion. So I'm not sure if I'm supposed to be arguing or he should just be arguing against. Because I have some things that I'd like to put on the record because it's my motion to quash. If that's what we're arguing, Judge, and I'm sorry, I want to stand up. If we're arguing my motion to quash, it's my motion. So I'd like to argue my motion, and then if there's counter to the argument, I think that it's fine. I mean, it's up to the court, obviously. He's on a roll. I'll let him go.
Thank you, Judge.
He's doing so good.
Okay, so Judge, so not only do they put in their motion to quash, not only do they put listen to the detective and listen to the cooperating witness and don't let me take the deposition, but then they get into the facts of that he has nothing to do with this case, etc. I think it's clear that when the court vacated the prior order, it did so with the intent of them working together. They failed to do that. And Judge, just to give the historical background of how we got here, I filed a motion to perpetuate Mr. Graham's testimony. The court denied it, but the court at that time, and I know Mr. Cohen wasn't involved at that time, so for his benefit, the court said, why don't you just take his depo and everybody be on notice that when you do so, give it the same scrutiny that you would, because if he's unavailable, we could read it at trial. So here we are, the case is ongoing, okay? Time is of the essence, and what they're doing now is they're trying to block any efforts that exist. Now, just to be clear that the reasons why his deposition is important historically is, for starters, Mr. Onfroy, prior to his death, put a post that says, if anybody kills me, it's Drake. Number one. Number two, in that same year, in a song called Upset, he put XXX SMS, I only shoot below the neck. Fast forward, that he's seen and shot below the neck. Antonio King comes to South Florida for the sole purposes of intimidating on behalf of Drake. And then, post-murder, he puts in lyrics, things like, you know, if you would have kept his mouth shut on IG Live, you'd still be alive, or Louis bags for body bags. It seems like he can't stop talking about this murder, but he doesn't want to get deposed. And it's clear that he doesn't want to be involved, he doesn't want to be deposed, but the legality of my client being able to defend himself and to investigate this case has never been an issue, Judge. And the court, and I understand why the court vacated the rule of clause, because he hired Brad Cohen, arguably one of the best attorneys in the United States, and the
So
court
now
said,
you're not disagreeing with everything he says.
yeah,
I almost want to just stipulate.
I was going to say
stipulate to that.
I was going to say Florida, but I'm going to give him the U.S. So he came in here. He's doing a fine job, Judge. But at no point was this court gave anything but an indication of work together and let's get this accomplished. And that's not happening, Judge. And I filed a motion for expedited deposition and for rule of cause. And I know he's saying that it's not right, but I need to bring this to a court's attention because trials ongoing. So I just wanted an opportunity to be heard and to let the court know what's going on. Did I drop a subpoena on him the day after he was here in court? Yeah, I did. Because he filed a notice of appearance and he legally cannot not accept service. That's clear.
That's a double negative.
Well, regardless.
Just for the record, that's a double negative. Am I ready? Thank you. That was a very passionate argument.
Thank you, sir.
I don't even know where to start.
I learned from the best.
You did a great job. Let's start with the service of me. Okay? And then I'll get into the cooperation part. And then we'll get into why it should be quashed. But let's talk about the service of me. The service of an attorney that files a notice of appearance. Mr. Padilla is mistaken. That's in a case where there's a party and I file a notice of appearance. The case that he gave you, that's a party. That's a writ of garnishment. If you look at the Florida Rules of Judicial Administration 2.516, it specifically lays out, accept applications for witness subpoenas and documents served by formal notice or be required to serve in a manner provided by the service of formal notice. That's for an attorney. I was here on that Monday, the 13th, and I said in open court, I am not authorized to accept service on behalf of Mr. Graham. I notified everyone I'm not allowed to accept service. Now, even putting that aside for a moment, when they came to my office to serve, the California lawyer asked me if I'd accept service hours after it was already served. But they came to my office to serve. I was not in my office at the time. The subpoena itself is directed to me personally, not my law office, as part of whatever service they thought they could have. To me personally, the individual comes in, and Marlene Cohen, my mom, who's 82 years old, is at the front desk, and the guy says, hey, I got papers for Brad Cohen. She says, oh, okay. Leaves them at the front desk, and when I get back later on that afternoon, like 4 or 5 o'clock, I open it up, I see there's a service of process. Why that's so important is, number one, is it's not effective. And the case law is not relevant for this. The Florida Rules of Judicial Administration 2.516 specifically outline that an attorney can't accept service without authorization for a witness subpoena. Now, putting all that aside, that Monday, after the hearing, when we were before Your Honor, I called Mr. Padilla and I said, listen, I understand what the judge said. I still cannot accept service. But hearing what the judge said, give me a list of questions, okay? And let me see if I can fashion something where maybe these questions will resolve all of our issues and we can move forward. And Mr. Padilla essentially said, well, either you have to accept service or you can't. I don't want to waste my time, and I don't want to put words in your mouth.
How are you doing it?
Okay. I don't want to put words in his mouth, but it was, and I'm paraphrasing, but it was something to that effect. And I said, I don't have the authority to accept service. That end of that conversation. The next day, I get served the subpoena, and I think it was around noon at my office. And I then get an email later on that day from a California attorney that says, will you accept service via email? It was already served, but will you accept service via email of this subpoena? And I wrote back, and I have the actual email here that I wrote back, that I said, I am not authorized to accept service, nor is anyone authorized that I know of to accept service on behalf of Mr. Graham. Fast forward to the 18th, and now the order to show cause is filed prematurely before Mr. Graham is either, the deposition would even be set, and I write to Mr. Padilla in another email, and that's dated Saturday, February 18th of 2023, and I wrote, I just want to make sure that we're on the same page, and I'll make this part of the record, Judge, but I want to read it. On Monday, I asked you for a list of questions as I could not agree to a date without a list. You need a list. I also could not accurately limit the questioning and the scope without a list of questions that were being proposed. I wasn't provided with anything, and I was left with the choice to accept service first, and then we will give you a list of questions. That obviously I could not do. Service was then attempted on my office after I said in open court that I could not accept service. I told everyone in open court I did not have the authority to accept service. I told your colleague in LA via an email that same day of bad service, I could not accept service. In fact, I told her no one is authorized to accept service on behalf of Mr. Graham at this time. Knowing that, I still sent a process server to my office. As no one provided me questions, I will provide the suggested questions and scope. Again, at this time, it is not a waiver of any proper service or any type of agreement that proper service has been completed. I believe this is the most prudent thing going forward. Obviously, we are not agreeing to getting into anything further than these areas. I gave a list of 5 questions, 6 questions. Do you know these 4 individuals? Does anyone you know these 4 individuals? Have you ever had contact with these 4 individuals? Does anyone you know ever had contact with these 4 individuals? Do you know anything about the incident that took place on the 18th that was not public knowledge? Where were you on the date the incident took place? I don't know what else we need. There have been several witnesses that have taken the stand that have said, and I'm not saying believe one witness over another. I'm saying the evidence before the court is this. Witnesses took the stand. One of them was a detective. One of them was, I think, a layman. I think it was 3, actually. A detective, a defendant, and a layman who I think identified the body. The detective says, Mr. Graham has nothing to do with this case, and I don't know any information other than rumor and innuendo on the internet that has anything to do with this case. The defendant, the cooperating witness, takes the stand and says, I know of Graham, but I know that he never paid me. He didn't pay anyone. I don't know him. I never spoke with him, and none of these guys ever did. And then the third witness takes a stand and says, I don't even know of any kind of rap beef. Is what and I don't know anything that's going on. So when we say like what we believe and what we don't believe from an individual, that's different than what's before the court, what's actually in evidence. It doesn't matter what I think is believable, not believable, or anything like that. I'm not the jury. The question is, what is before the court regarding Mr. Graham having anything to do with this whatsoever? And the answer is nothing. So far, there is nothing. The tweet that we're speaking of, 10 minutes later, it was like someone broke into my Twitter. So that was innuendo. The songs that we speak of are all innuendo. There's not even, they haven't even put on any evidence that Mr. Graham was even in the state of Florida, made a phone call, talked to somebody, a text, an email. I mean, I'm getting into my motion for protective order, which I don't know if that's right yet, because I still want to argue this motion to quash. But I went on in my email and I said, and I discussed this with Mr. Padilla. We all know Mr. Graham had nothing to do with this incident. And in fact, the incident was caught on video. It was a flipping witness, and there are photos, money's taken from the victims, their phones are on scene, they were caught eyeing the victim in Broward Motorsports, they were caught in a getaway car. I certainly do not want to limit a defense to any crime. I'm a defense attorney. I understand that you got to raise the issues that you need to raise. But I said, but if you're, well, this is kind of funny. But if your client blamed John Wick, not suggesting you need to take Keanu Reeves' deposition, it would be more believable. There's nothing to put him even in the realm of reality in this case. If you agree to the above questions, now we get back to the questions. I will certainly see what I could do to avoid bad service situations like the ones most recently had. So, in terms of the cooperation, I can't say that I'm going to accept service, nor can I say anyone's going to accept service until we limit this, until I see what these questions are. But I don't even think we need to get there. I understand the court wants to give this defendant as much defense as they should have, and I get it. Everyone's entitled to a good defense. Everybody is entitled to it. I'm a defense attorney, so I argue that all the time. But at the same token, it needs to be based in some kind of reality, some kind of information, more than innuendo, more than a tweet. Something to say, hey, this guy has something to do with it, because you know what? Witnesses have rights too. And here, this is an individual that is now besmirched by these accusations. There's blogs, there's people that are emailing me, questioning things. And where are his rights at this point? Where I have nothing to do with the case. And I know Mr. Padilla is ready to chomp at the bit to say he made a rap about it. Great. He made a rap about it. That doesn't subject you to getting cross-examined on the stand or cross-examined in the deposition on something that there is not a shred of evidence, not a shred of proof that you had anything to do with this case. So I know I'm arguing my motion for protective order. My motion to quash is, I can argue that as well. I'm not sure if you want me to address that, but the service on me is no good. Just to give you a nutshell, the service on me is no good. The service on Mr. Graham, or the attempted service on Mr. Graham, is no good, and I'll tell you several reasons. Number one, right off the bat, they don't even have an affidavit that says they know this is Mr. Graham's house and how they know this is Mr. Graham's house. Number two is the actual service, the drop serve that he dropped. I submitted with my motion the picture of and the testimony from this guy. I'm glad that he actually testified, because he testified he dropped it in a sealed envelope. Pursuant to California law, you can't drop a document in a sealed envelope. If you're going to drop serve, it has to be dropped in its entirety so that the individual can see what you dropped before them. That is a very clear California law. Now, what's even worse than that is he said, well, I'm allowed to serve a security guard. No, you're not allowed to serve a security guard. You are allowed to serve a security guard in a gated community, which this is not, which the testimony was very clear from this individual, or a multifamily house, which he did not testify this was a multifamily house. In fact, quite the opposite. He testified this was one big, gigantic house with a sealed gate. The attempted service on Mr. Graham fails for several reasons. And I'll tell you something, Judge. This is an individual who not only the day after this alleged service took place, he was in Rodeo Drive having lunch. There are ways to properly serve this individual. It's just they ignore it. They want to do substitute service because that's the easiest, but it's not. He's been in Florida. He's been in California. He's been in Texas, and not to mention, by the way, he has a Canadian passport. They have so many problems with this service. It's like I could go down the list of issues that they have with this service. But I think the beginning part of it is they're hiring process servers that I don't think understand the process. And Mr. Baird seems to be a very nice man. The problem is what he's saying is incorrect. That is not California law. You can't serve a security guard unless it's a gated community, multifamily house. Additionally, you can't drop serve someone with a document that's in the envelope. It has to be outside of the envelope. And I put that all in my motion. What they really need is they need like Seth Rogen from Pineapple Express to go deliver a package and say, you're served. It's not that hard. I have served ex-presidents of countries. I've served individuals that are nationally and internationally known. I've served ex-politicians and current politicians. And I've always personally served them because I know the service laws, and my process servers know the service laws. And they find them and they serve them. So if we're talking about the motion to quash, I think it's very obvious that it was not good service. But putting that aside, I don't even think we should have another attempt at service. We're living in la-la land here. There is nothing to attach Mr. Graham to this other than blogs, emails to one guy to another saying that, I think this is what's going on, a tweet that came out and then instantly came back. I understand it, Judge, and I understand the trepidation of the court not to allow a defense for someone that listen, we can all be very honest with each other. We don't want a case coming back on appeal. Nobody wants a case coming back on appeal. And I think that in order to do that, you want to afford the defense as much leeway as possible. But there is a limit. The law has a limit on it. And we are a country of laws. That's why we have to adhere to them. And if we don't adhere to those laws, then why are they there? This individual has nothing to do with this case. Everybody that is involved in this case knows that he has nothing to do with this case. And we are sitting here talking about taking the deposition of an individual who shouldn't be involved in this case whatsoever. Now, that is my argument to just get him out completely. But this service, whatever was going on, this has to be quashed. This was not good service. They can attempt personal service. And California law actually specifically states you need to attempt personal service at least 2 times. They say 2 or 3 times before you can try substitute service. These guys just keep trying to serve process server, try to serve security guards. And security guards are not allowed to accept legal documents. For all my clients, I don't know a security guard that works for any of my clients that is given instruction, if someone comes to serve somebody, you should accept service. Not one. And that is because they cannot accept legal service. Because we don't know what it is. We don't know what they're asking for. This guy could have proposed anything. He could have said it's for a deposition. He could have said it's for a lawsuit. It doesn't matter. We're not allowed, the security guards are not allowed to accept service on behalf of anyone. So for those reasons, Judge, number one is, I think the process of service, it's not even a close call. I think the process of service has at least 5 to 6 things why it fails. Not to mention that the affidavit itself is incomplete and not applicable. But I think that we should, at this point, now looking at the testimony that has been given to Your Honor on a detective, a layman, and a cooperating witness, that everyone says Mr. Graham has nothing to do with this. I think at this point, we have enough to say enough is enough. You can make the argument all you want, but there's no reason to have Mr. Graham on a deposition or force him into court to give any kind of testimony, Judge.
Judge, we've heard a lot of Brad because I say. You know what you didn't hear? You didn't hear his California process server or his expert come in here or an affidavit from his California attorney, because the only person that's filed one from a California attorney is me. He just keeps saying and repeating California law, and that's inappropriate. He would have had to have somebody come in here that's the appropriate person to educate this court regarding California law. Now, I really think that you have to have the audacity to come in here, no matter how rich Mr. Graham is, to come in here and argue that his attorney is trying to negotiate the exact questions that are going to be asked of him in a deposition, or I'm not accepting service, because Your Honor was clear. Your Honor said, this is when you were being nice and extending professional courtesies. We can talk about the topics. No one's going to tell Mr. Padilla questions to ask. It doesn't make sense to make me go and take a deposition and specifically ask the questions. Now, it speaks volumes about what they're trying to avoid and what they're trying to do. I wasn't even going to bring up the email because it was, I thought, settlement negotiations between us. I'm glad he did, so the court could see how involved Mr. Cohen is and still not accepting service. So I believe that speaks volumes. I understand Mr. Baird is 81 years old. You know what, everybody, I'm glad that at 81 he can still work, just like Mr. Cohen's mom is 82. I'm glad. I think he did an appropriate job. The video speaks for itself, Judge. You've seen it. They're obviously there's no evidence. There's no evidence. A deposition is my opportunity to get evidence. And they're trying to prevent it. Now, Judge, just really quick, regarding Curcio, what did Curcio say? Curcio said that Mr. Graham was so important that back in 2018 that they did an investigation to try and find out whether or not he was in South Florida. So we've heard testimony that he was at least important enough to try and figure out whether or not he was in South Florida June 18th of 2018. And if that's the case, and if law enforcement is going that far to make that investigation, then that's more than enough, besides everything else that I've discussed, to allow me to take the deposition. What you also heard from him was when I asked him, isn't it true that the first time that the name Migos came in this case was out of your own mouth? And I had to show him a transcribed phone call between him and the cooperating witness a month after the murder, where he had to admit that the name Migos came up a month after. And that wasn't from my mouth. That was from his own mouth and from the cooperating witness, Mr. Allen, in July of 2018. So I think that I've shown that there's enough. And Judge, it's never been a question. It was never a question. It was, take a step on it. Of course, there's enough there. Let's figure this out. They don't want me to take the devil. They don't want me to get evidence. And the gamemanship is crazy what's happening here, Judge.
All right, let me address a couple of things first. With respect to attempted service of Mr. Cohen, Mr. Cohen indicated he was not here to take service. The rules of administration do not allow discovery, deposition subpoenas to be served on a attorney who does not agree to take it for them or is not specifically authorized by the client to take it. The case that you provided, Watson versus Stewart, even in there, it indicates that Florida law is well established that service process and any defect in service can be waived by a general appearance. However, active participation in proceedings, especially without objecting to jurisdiction due to lack of service, constitutes a submission. All of his pleadings are attacking the service and saying, oh, we're not subjecting ourselves, and refers to a non-party. So the case that you cite is actually contrary to the position that is appearing here to fight the process is somehow submission to the process. Secondly, I don't find that the drop service in front of a security guard at a residence, which defense counsel purports belongs to Mr. Graham, but again, I don't have that evidence. It is correct that he is a Canadian citizen. He owns property here. I don't know that that's his residence. I don't know that that's the place that he ordinarily sleeps at. I don't know these things in order to be sufficient to come in and then ask for a rule to show cause or writ of bodily attachment. It's just not. I made my ruling. So, secondly, when we come down to this issue of whether there should be a protective order, how far this will go, the court has done what it can to try and afford the defendant his rights. Both the Sixth Amendment to the United States Constitution as well as the Florida Constitution guarantees you a right to compulsory process. And in light of that is why I said, well, take a deposition, do something, show me something, how this witness that you've listed is somehow relevant to this case. And there's plenty of case law that says, the right to compulsory process is meaningless unless it can be backed up with judicial action through contempt or writ of attachment. And that, a defendant has a right to put on their case and their theory of the case. However, again, Mr. Cohen brings up that the right is not unfettered. You can't just harass people who are not involved in a case. And let me cite to Hoskins versus Wainwright. It is a federal case out of the Fifth Circuit from 1971 at 440 Fed 2nd 69. And I'm quoting in pertinent part, the right of compulsory process is not absolute. And the state may require that a defendant requesting such process establish some colorable need for the person to be summoned, lest the right be abused by those who would make frivolous requests. And it also cites back to Washington versus Texas, a 1967 case decided by the United States Supreme Court at 388 U.S. 14 or 87 Supreme Court 1920. Which again discusses that there is certainly a right to compulsory process and a right to call witnesses for your defense, and this is basic to our system of justice. But it's not unfettered, and there comes a point where it can become abusive. Ashley versus Wainwright are cases out of the state of Florida. Got kind of a history. There's Ashley versus State at 433 Southern 2nd, 1263, a first DCA case from 1983. It was further then appealed, Ashley versus State, 479 Southern 2nd, 837 in 1985, same case, and ultimately made it into the federal system under Ashley versus Wainwright, 639 Federal 2nd, 258. And again, in that case, they, quoting what the court's already expressed, the right to compulsory process is not absolute. And the person making the request can be required to establish a callable need for the person to be summoned, lest the right be abused by those who would make frivolous requests. And it, again, goes back to the Washington versus Texas case, where in that case, the U.S. Supreme Court reversed the conviction, saying in that case, the state had arbitrarily denied the petitioner the right to call a witness who was physically and mentally capable of testifying to events that they had personally observed and whose testimony would have been relevant and material to the defense. So I'm asking you, counsel, not some tweet made by or Instagram post or some other post made by another person, not by a person who's not Mr. Green. And later that with the same degree of reliability or authenticity, there's also a tweet or Instagram or whatever saying that I didn't post that. That was a hack. Okay? So those are the only two things that we have up there. And if that's all you have, then this is a fishing expedition that the court is not going to sustain any further. We're getting outside the realm of what is a colorable, legitimate defense, and just turning into harassment on it's like a Chewbacca defense.
Except, Judge, that I've already put in writing when the court ordered me to do so, the nexus between my witnesses in this case, that Antonio King 600 Breezy did in fact fly to South Florida and did in fact post video of himself threatening to be armed and threatening the decedent prior to his death. He further, I know, but I'm letting
counsel, then subpoena 600 Breezy, what does that have to do with someone else?
I'll tell you.
Who have no evidence of being involved other than hearsay and innuendo, you are now trying to just drag somebody in who's a celebrity who does not want to be associated with this, and the harm to that individual is not inconsequential.
I'll tell you why. Because that person, Antonio King, then further posted that the reason that he came down here was for Drake. So I'm not making this up. This is out there. But I'm not being allowed to investigate it. All I want to do is take his deposition.
You've had this case since 2018. Go talk to Breezy.
He's on my witness list. I don't know where he is, but Judge, listen. Look.
But that's a different hearing. The hearing here is whether or not there are sufficient grounds for this court to order somebody who I have no evidence, and counsel's questions saying, are you aware of, is not evidence. We're all aware that your questions are not evidence. So the detective who investigated the case said he finds no nexus. The relative of the deceased who came in to identify the body said, yeah, I'm not aware of any beef. And when you showed the screenshot of that, said, yeah, you know, he disavowed that as being hacked. Was he hacked that time? I don't know. His account's been hacked a number of times. This is beyond you know, what would be considered something that can be authenticated. This is beyond triple hearsay. This is just gossip, rumor, and innuendo, and really doesn't have any place in a court of law.
In any other scenario, if it were not Aubrey Drake Graham, and it were anybody else, and it comes out that before he died, he said, if I die, it's so-and-so, I get to ask you at least, Mr. Graham, do you know Robert Allen? Do you know any of the other co-defendants? Have you ever communicated with them? These are questions that are normal in any scenario. However, and listen, Judge, it's not my fault that the decedent was a rap star, and the person I want to depose is a rap star. It's the Home Depot, like I said, if a decedent worked at Home Depot, I'm probably going to have some people from Home Depot on my witness list. This is no different. The issue is that the people at Home Depot can't hire Brad Cohen. And Brad Cohen came in here, and all of a sudden, now I'm not even able to exercise my client's right to investigate this case. All I wanted to do was to take his deposition. There's been more than enough from the detectives, and frankly, Judge, that relative, that's a lie. Because everybody, 50% of the population knew about the issues between Drake and X. Everybody knew it. I believe that she lied on the stand, which is really raises an eyebrow on why that person's going to perjure herself for that question. So, Judge,
your opinion, counsel, is not facts before the court. It's not the testimony before the court. Again, I'm mindful of your client's right to present a defense, and I have gone as far as I think I can to allow him his opportunity for process. But at this point, it appears to me nothing more than harassment of someone in order to set up some sort of straw man, look over here where there's no evidence of that. In fact, even you're suggesting that if your questions are, do you know my client? Have you talked to any of these people? That does not absolve them of the charges before them. That's not a defense. At best, that would be adding a unindicted co-conspirator, if you will. But that's not a defense to the individuals that are here. And
Judge, that was just a sample of a question that could lead to another question. It's a question that should be asked of someone. And if it weren't Graham, I would be asking. I would be able to be asking.
No, it wouldn't. Because if it were a guy at Home Depot who came in and said, Judge, I don't know why I'm being dragged in here. I have nothing to do with this. I don't know these individuals. I didn't kill anyone. I don't know anything what you're talking about. They would be entitled to the same relief. It does not matter. And additionally, so your motion's granted.
Thank you.
Your motion's denied. And lastly, I just, even though Mr. Hope's not here since he already won on these things, I don't think you mind that. I just want to supplement with respect to, on your request for his client, Linwood same kind of thing. And for that, I will cite to Sewell, S-U-L-E versus State. That is a fourth DCA case at 968 Southern 2nd 99, which in that case, pertinent part, the court indicates that the defendant argued that the trial court abused discretion and violated his constitutional rights when it excluded trial testimony of his son because Christopher invoked his Fifth Amendment privilege against self-incrimination. State counter, since Christopher refused to waive his Fifth Amendment privilege, the court correctly ruled he would not be permitted to testify. Goes on to say, an accused has a right to present his own witnesses to establish a defense. The defendant's right to present witnesses in his own defense, however, does not carry with it the right to immunize the witness from reasonable and appropriate cross-examination. In an analogous situation to this case, we have held that a trial court does not abuse its discretion in excluding witnesses who, through the invocation of this privilege, would imply that someone other than the defendant has committed the crime. So if you merely call someone in here to accuse them and then have them say, I've got my own troubles and I'm pleading the fifth, is not appropriate. And so I cite that case for the exclusion of Mr. Linwood, and I think to some extent it also applies here in that the Graham, there's nothing before this court that's actual evidence that would suggest that he's involved in any way other than gossip, innuendo, and unsubstantiated tweets that the repudiation of the tweet is as strong as the suggestion of the tweet itself, neither one of which can be authenticated, and neither one of which are substantial or competent evidence before this court. Thank you.
Thank you, Judge. Thank you, Judge.
Judge, before you go, if I could ask the court, Pascal Schell on behalf of the state, because I've been watching the hearings and proceedings. I'd like to renew my motion to strike these witnesses because I know that Your Honor has previously said that it wasn't right because you allowed Mr. Padilla the chance to have a defense. Listening to the court's the testimony today and the lengthy ruling that the court has given, I believe that it would be right at this time. I'm asking for these witnesses to be stricken in the murder trial because of the testimony that has been
Which
given today.
witnesses specifically?
Mr. Graham,
I will grant the state's motion to strike them from the defense witnesses.
okay, and I'm asking with respect to that there be no further argument as to that, as a motion in limine, that there be no further argument referring to Mr. Graham or any of Mr. Graham's associates. I'm also asking for if there were 30 witnesses, I think, that were part of that 57 list, none of which is there any evidence based on the court's precedent for the ruling today? And so those witnesses from that list is what I'm asking to be
I'm
stricken.
not going to strike them at this time because there has not been an attempt or showing. If there can be a showing, then, I mean, I don't know, which is the same reason why we got into the situation with Mr. Graham.
Okay,
I don't know what he had or does not have.
okay,
At this point, I know what's been presented and what I think the argument is based on some songs that were made after the fact and I don't know if it was a tweet or an Instagram post that was later repudiated, neither one of which can be authenticated by the supposed author. And based on that, I have enough to make a ruling with respect to Mr. Graham.
okay.
The other ones, I don't know what he has or what he doesn't have. He's not asking me to take further action on it at this point, so I'm not closing those doors.
Okay, Judge. So that's clear. So with respect to Mr. Graham, Your Honor has stricken him from the murder case. Are you also allowing my request, which is for further argument and further mention regarding that, to be stricken as well or to be prohibited? Because I asked for that as a motion in limine.
She's opened the door. She's the one that asked in her direct a bunch of questions about.
I'm not going to
actually,
defense
Judge,
whether I think that's a good strategy or a bad strategy, but I'm not going to preclude him from making arguments based on what's here, not on, there is no evidence before this court or this jury of any Instagram posts. They're not in evidence. They should not be argued as if they're in evidence.
Judge, I actually, you know what? I'll withdraw my last request. If Mr. Padilla wants to go down that road after it's already been stricken and argue about testimony and evidence that's not in this case, I actually think the state would probably prefer that. That might be.
Agreed.
So,
Agreed.
okay.
In any event, that's where we're at.
Thank you, Judge,
Thank
thank
you.
you so much.
Appreciate it. We are in recess.